Thank you so much for joining us for the third in our estate planning webinar series. We're very pleased to have Candice and Matthew and Vlad with us today. If you've seen any of the other webinars, you've seen Candice and Vlad, and we'll get to who Matthew is in a second, but I just wanted to welcome you all and thank you for coming to this webinar series. We are Wildlands League, a nonprofit charity that is engaged in protecting the natural world. And this is an estate planning webinar series provided for by these volunteers who've come to help us out. And I'm going to turn it over to Eugenia, who will help us guide us through in terms of the housekeeping rules so that we can do this webinar and you can all enjoy it the best possible way. Eugenia. Sorry.
Great, thanks so much, Janet. Welcome everybody. I'm Eugenia, I'm the Outreach Manager at Wildlands League. Really excited to be here and learn from our financial advisor and from Matthew today. So a few housekeeping rules. If your videos and speakers are unmuted, they should be muted. If you're listening via the phone, please make sure that your microphones are muted just so that we can reduce any background noise. If you notice any of the presenters' faces are covering any of the presentation information, you can adjust this using your personal settings. If you have a question, we have a Q&A box at the bottom of this screen, so you can enter your questions in and we will try to answer as many as we can. I will be monitoring the questions today and we'll try and answer them towards the end of the webinar. If you have any burning questions, feel free to put them into the box and I will be on the lookout for them as well. Other than that, sit back, relax, and enjoy. Thanks.
Thanks so much, Eugenia. So you can go to, this webinar is the Estate Planning Simplified, Considerations Beyond the Will, Legal Issues. But I'm going to go to the first slide, if you will, Eugenia. Thanks very much. So this is a picture of one of our Paddle the Rouge events. And the purpose of this slide is just, oh, sorry, I guess it has an automatic setting. So we'll try to keep it here just for a second. We're having some technical difficulties today and Eugenia has stepped into the breach. And so please be patient with us. But this is just to remind us that when you give a gift in will or any major large donation to Wildlands League, in fact, even any donation from an individual, it really helps us because what we have is we get a good amount of our funding through foundations and through grants. And those grants are tied. That means that they come in and we are required to perform the work that we've set out in the terms of the agreement. And it doesn't give us much flexibility. It doesn't allow us to be as creative as possible. And when you're trying to come up with new policies and legal mechanisms and frameworks to protect the natural world, it really requires having some flexibility and some ability to act and react and be innovative in trying to advance solutions and working with companies and industry and with government. And so this is an example of one of those events where we did a Paddle the Rouge event, which was to create awareness about the values of Rouge National Urban Park, where there's almost 2,000 species there, where we started doing events over 6 years ago now. And we've probably trained about 1,000 youth in how to paddle over that 6-year time frame. And so I just want to say that when you give a gift in will or a major or even a small donation to Wildlands League, that allows us, those are untied donations and allows us to be more proactive in how we take on the challenges around protecting nature. It also allows us to do more investigations, any legal challenges, those kinds of things. And so thank you very much if you are donating, and thank you very much for considering if you haven't donated yet. And so I will now take us to the next slide and introduce Matthew. So we have actually 3 experts with us today. You'll hear from Candice and Vlad at the tail end of the presentation, but I'll give you a little bit of a bio about each one of them. Matthew Urbach is a lawyer practicing in the areas of estate, civil, and commercial litigation. Matthew's particular focus on estates, wills, and trust litigation has enabled him to develop experience with a variety of practice areas within this field, including will challenges, guardianship applications, passing of accounts applications, solicitors' negligence, and other estate disputes. Matthew also has experience drafting wills and powers of attorney. Matthew regularly writes articles and contributes to stories about current issues in estates law and has been featured in the Lawyers Daily, Investment Executive, CBC News Radio, and the Financial Post. Pretty impressive. I will now move to Candice. Candice J has over 15 years of experience in the financial industry and has her own practice under CC&L Private Capital. Prior to joining CC&L Private Capital, she was at Pembroke Private Wealth Management and HSBC Global Asset Management. Her practice guides and works with charitable foundations and high net worth clients, with a focus on women, entrepreneurs, and families to achieve their long-term financial goals. Strategic philanthropy is also an important part of Candice's practice, and she is passionate in working with clients to identify values and areas where philanthropy can play a role. She holds the Chartered Investment Manager, CIM designation, is a fellow of the Canadian Securities Institute, and was awarded the Master Financial Advisor of Philanthropy designation in 2020. Candice understands the importance of giving back to her community, and she is a current board member of the University of Toronto Alumni Association and UHN Impact Collective of the Toronto General and Western Hospital Foundation. She is also a member of the Canadian Association of Gift Planners, leading engagement and mentorship for professional advisors in the GTA chapter. In her spare time, if she has any, Candice enjoys practicing yoga, playing golf and tennis, and taking hikes with her family and golden retriever Sadie. Next up is Vlad. A little bit about Vlad. Vlad Solokhine is a certified financial planner with over 15 years of experience in the financial services industry. He is currently a team member at Lazar-Wealth Succession Strategies, a financing planning boutique in Markham, Ontario. Before starting his own financial planning practice in 2012, he had the privilege to work in a major Canadian bank, an insurance company, and a mutual funds company in advisory and senior management roles. In his practice, Vlad specializes in philanthropy-focused financial planning, helping people with disabilities and people in career transition. He is the chairman of the board of High Notes Avante, the registered charity that inspires people touched by mental illness through artistic expression. Vlad is also a member of the Professional Advisor Committee of the Canadian Association of Gift Planners. And Vlad lives in Markham. In his spare time, enjoys family activities with his wife and 3 children. An interesting fact, which I personally found very interesting, is Vlad has a bachelor's degree in physics. Physics is one of my favorite subjects. And so without further ado, I'm going to turn it over to our 3 experts who have been providing their wisdom on all things estate planning. And we'll kick it off with Matthew and then finish off with Candice and Vlad. Thanks very much, Matthew.
Thank you very much, Janet and Eugenia and the entire Wildlands League for having me today. And thanks to Candice and Vlad as well, and to all of you for joining us this afternoon. So let's get started. First, I'm going to summarize a little bit about what I'm going to speak about today. First, I'm going to start with a little bit of an introduction to will and estate planning and sprinkle in some considerations, some new considerations now that we're living in a COVID-19 world. I'm going to talk about a little bit about what you can do in your own estate planning and will drafting possibilities. And then I'm going to conclude by talking a little bit about managing taxes and extending your values beyond your lifetime. Why is estate planning important? I have lots of people ask me, why should I bother? Why should I go to all of this trouble? Isn't it just easier to let other people deal with it after I pass away? And to that, I usually say that you end up leaving quite a bit of a mess for your loved ones and friends if you don't plan in advance, because what you do in that sense is you cause your family and friends to assume as to what you wanted to do with your assets on your death. And the benefit of estate planning is to avoid assuming and to avoid all of these emotions which can come to the surface if your wishes are not clear, including family resentment and feelings of inadequacy, competition, hurt feelings, jealousy, anxiety. These are all issues that could be boiling under the surface within certain families or friend groups. And I have seen, unfortunately, in a number of occasions that a dispute over an individual's estate and estate plan may not be the cause of all of these issues, but it can certainly be the trigger. So it's best to avoid all that. And in order to carry out your wishes properly, it's always best to speak to experts, people like Candice and Vlad as well, to make sure that your wishes are carried out. And on that note, how can we use charitable giving in our will and estate planning? Well, in Canada and in many nations around the world, we have our taxation theory, which simply states that everyone has to contribute to society. And the ways in which most people, all people, do it is by paying taxes. Now, in Canada, we're very lucky in that our public policy is extremely generous for those who want to contribute and give to charity. It treats giving to charity as essentially equivalent to paying taxes. So the more you give to charity, the less you will have to pay in taxes. So in many ways, it's your choice. Do you want to give to the CRA or do you want to give to charity? Oftentimes when I ask people that question, you won't be surprised to hear that the answer is fairly clear. So let's start right at the beginning. Right at the basics. What is a will? It is a written legal declaration. You cannot orally dictate your will, in which two things are generally done. The first is that it names one or more people to manage the estate. That is your estate trustee or your executor. And secondly, it sets out how and to whom your property is to be transferred at death. Who is your property going to go to when you pass away? Is this a will? Let's assume that I wrote this out in my own handwriting. Please excuse my rudimentary skills on Microsoft Paint, but assuming I wrote this all out in my own handwriting and signed it at the end, this indeed is a will, believe it or not. It's not a good will. I would certainly not recommend using it, but it is a will. Our law set out that you can make a will in your own handwriting as long as it's exclusively in your own handwriting and signed at the bottom. It's not as a traditional choice as you see as the usual typewritten will, but it is in fact a will and it is valid. Okay. Why don't we go to the next slide? Thank you. So a more formal will that you may have seen more of is a typewritten will. It's signed at the end by the individual who wrote the will, and it's in the presence of two witnesses. So your will has to be witnessed, if it's not in your own handwriting, by two people who do not benefit under the will. If they do benefit under the will, that signature, that witness will actually invalidate their own gift. So it's always best to use someone who doesn't benefit under your will. The interesting thing that's come up over the past few months with social distancing and now that we're living in a COVID-19 world is many people were asking, what does in the presence of witnesses really mean? Are we in the presence of one another, for example? And the lawmakers have determined that for the purpose of making a will, this over the internet, by using audio-visual technology, is indeed presence. You can have your witness to a will be present with you by audio-visual communication technology, provided that one of your witnesses is a lawyer, and yes, that is valid. The other consideration that came up is usually, before all of this happened, your two witnesses and yourself would be together in a room, everyone would sign the same document, and that in itself would be your will. But it's a little harder these days, unfortunately. So the legislature stepped up and said that your witnesses may sign, at least for the time being, may sign separate copies of the same will as long as it's identical, and putting it together back to back to back, say the copy that you signed, the copy that witness one signed, and the copy that witness two signed, back to back to back, putting that together, that in 2020 is a valid will. So I'm going to talk a little bit about some failed or questioned wills that I've actually taken some examples from my own practice just to show that it's really easy to have little mistakes or little issues in a will, which will make all sorts of trouble for your loved ones if it's not checked or made sure things aren't done properly. So take a look at this example here. This is, again, an actual will that I came across, and it said, my property to my son, Jonathan, If my son is deceased, my property to the children of my son Jeffrey. But if my son Jeffrey has no children, my property to my son Jonathan. So it's quite circular here and made us scratch our heads a little bit. But what happens if you just change one word in this will? If we could go to the next entry, please. Let's change one word. My property to my son Jeffrey. If my son is deceased, my property to the children of my son Jeffrey. And if Jeffrey has no children, my property to Jonathan. So one word changed the entire character of the will in this case and made a will that looked like it was almost incomprehensible to something that actually makes a lot of sense. Other issues that can come up are wills that omit an expected beneficiary. So no one is entitled on first glance to be a beneficiary of your will, but certain people expect it, even though you don't necessarily have to give them anything. For example, children. If you have 3 children and you want to give to 2 of your children, but not the third, oftentimes the third child will argue that the person who made the will must have forgotten about them, so the will isn't valid. So what people have done in response is to explain right in the will why that individual has not been left a gift or is even left a small gift. Perhaps they don't need the money as much or for really whatever reason. But it's always good to tackle these issues up front so there's not an issue when you're not around to referee it. And the important thing to take note of here is there's no obligation to treat people of the same class equally. If you have 4 nieces and nephews, you don't have to give to all 4 nieces and nephews equally. Other issues, when you fail to update your will, if you give a gift out of a specific bank account, if you don't have that bank account anymore, that gift is going to fail. If you don't have a piece of property like your lucky Toronto Maple Leaf sweater, or you think there's no such thing as a lucky Toronto Maple Leaf sweater, then that gift is going to fail. So the more general a gift is, the less likely it is to fail and not actually happen, which is obviously problematic. I came across this poll last year and I thought it was really interesting and worthy of sharing here. So Angus Reid asked a sampling of the population whether they had a last will in place, and half of the respondents said no, which to me is a very large number, but also quite notably, another 15% said that they have a will, but it's not up to date. So putting that together, that's 2/3 of the population, according to this sample, that don't have a valid up-to-date will. And the interesting thing is, what you'll see on the next slide, is that there's no particular consensus reason as to why people don't have a will or an up-to-date will written. Some people say they're too young, they don't have the assets, it's expensive, they don't want to think about dying, and it's too time-consuming to get a will written. And there's actually even more responses than this. I just didn't want to put them all in because the slide would be much longer. But what happens if you don't have a will? Let's take a look at the next slide. If you don't have a will, it's the government that decides what happens with all of your assets, which a lot of people, not surprisingly, find rather unsavory. And it's governed by our laws, and how your property is distributed is based on your family situation. If you have a spouse, if you have children, if you don't have a spouse and you don't have children, there's a whole line that you have to go down to determine who's the next in line. Parents, siblings, nieces, or nephews, and it goes all the way down until the last recipient is the crown. And unfortunately here, quite notably, charity is left out. So if you do want to give to charity, it's always good to try and consider your will and estate planning early on, because charity is left out if you don't have a will. So what can I do? Well, a good place to start is getting a lawyer, because of course lawyers can help you with your estate and your tax planning. I'm also often asked about these will kits. And my opinion is they are getting better, but I generally suggest avoiding them because they tend to be rigid. They're difficult to mold to particular circumstances. There's a lot of standard clauses. Each clause in a will has a particular legal significance. So better than nothing, but it's something that I would avoid, all things being equal. And take a look early and review it. What might be an appropriate will for you today may not be an appropriate will for you in a couple of years. And conversely, if you haven't looked at your will in 5, 10, 15, 20 years, it may be a good time to take another look and to make sure that it's indeed what you're looking for these days. I'm going to talk a little bit about probate. You may have encountered this concept in the past, but it's important to reference here. Probate is essentially having your will approved by the courts as the official last will and testament of the drawer. And it also confirms the appointment of your estate trustee, your executor. So in other words, it is that court stamp that confirms that, yes, this is the valid last will of the individual. And oftentimes people wonder, well, why should I bother with that? It's a bit of a pain to go through the courts. It can take some time. And the reason for that is because a lot of holders of your assets, banks being the best example, will not deal with the estate trustee, will not deal with your estate unless they receive a copy of that stamped will. They want to make sure that there's no funny business going on or no fraud or anything like that. So they're very careful to make sure that your estate trustee is acting under the right instruction. And not surprisingly, there's a cost for it. Starting this year, for estates valued over $50,000, it's calculated as $15 for every $1,000 of your estate. So the greater your estate, the greater the value of the tax. So as I said, it's effectively a tax. It's effectively 1.5% of the value of the assets that pass through your estate. And the way people try and avoid it is to minimize the value of assets that pass through your estate. And it may seem like a bit of splitting hairs when it comes to a distinction like that, but it really is quite important. Certain assets where you name a beneficiary, such as a life insurance policy, those assets, when you pass away, are deemed to flow outside of your estate, which means they're not subject to the 1.5% tax, whereas assets that flow through your estate that are governed by your will are indeed subject to that 1.5% tax. So when choosing an estate trustee, there's a lot of considerations to keep in mind. Obviously, you want to take into account someone who may be capable of asking, someone who's willing to take on the responsibility. And also in light of COVID, it's important to pick someone who may be able to complete the work if there's further lockdowns or quarantines. Of course, you want to pick someone who's trustworthy and reliable. And I also like to recommend that it's a good idea to pick someone with a certain degree of financial savvy. If you're thinking of someone who wants to run in the other direction as soon as they're confronted with a little bit of math, it may not be the best idea to pick them. Should you pick a family or friend, or should you pick a professional trust company? And just like everything, there's pros and cons to both. A family or friend may be more willing to be flexible, to act in accordance with your wishes. Trust companies can really only act in accordance with their own policies. A family or friend may not have ever done this job before, and it can be a difficult one, whereas trust companies often act in this manner, and they're truly a third party, which certainly has some benefit. And convenience, a lot of estate trustees are also beneficiaries, so it's a quick and easy way to skip a step in a sense, keeping everything to a tighter group of people. And on to the third part of my presentation this morning, and it's about considering charity as part of your estate plan. And there's many ways to benefit charity in your will. You can give in a whole host of different ways, and this is something that Vlad and Candice spoke about previously. What's also important to know is that the more you give in charity, the more it will offset tax that you have to pay to the CRA on your death. And let's take a look at the next slide for a little bit of detail on that. So as I said, you will lessen the tax that you have to pay in the form of a tax credit. So that's different than a tax deduction. I'm often asked about the distinction. So a tax deduction reduces your income. So for example, if you've earned $100 in a year and you contribute $20 to an RRSP, that $20 is treated as a tax deduction. So the CRA treats your income in that year as $80. A tax credit that you receive when you give to charity reduces the amount of tax that you have to pay. So if you owe $75 to the CRA and you have a tax credit for $15, that means you only have to pay the CRA $60. So tax credit can be a really powerful way of estate planning and minimizing, obviously, the tax that you have to pay, because generally speaking, you can offset up to 75% of your income by using tax credits, but in the year of death and the year prior, you can offset the full 100% of income in those years. You can also designate a charitable beneficiary of your RRSP or your RIF. In doing so, creates a tax credit, as we mentioned, and also allows that asset to pass outside of the estate to avoid probate fees. So it's actually a two-headed way of saving a bit of tax. And I know this is something that Vlad and Candice spoke about previously. What's also important to note is these days, changes to the legislation in light of COVID sets out that you can designate a beneficiary electronically now, which is something you couldn't have done before. And you also may want to consider giving a life insurance policy, either by donating the policy or naming a charity as a beneficiary of your policy. Again, this is something that Candice and Vlad spoke about quite a bit in previous webinars. So putting aside the tax component, obviously that's a benefit to charitable giving, but there's also that second benefit, what I'm calling the honor benefit, or the intangible benefit to your legacy and your estate. So how can you think of ways to leave your mark after you've passed away? And usually I think of trying to consider gifts that transcend time, either by directly giving, such as undesignated bequests, and keeping them general, as something like Janet spoke about a little earlier this morning, and investing in longer term gifts by projects that we know will be around for a long time, such as environmental conservation or protecting wildlife, and also investing in future advocacy. I've also mentioned donor advised funds here, which are a great little tool. I know, again, that's something that Candice and Vlad spoke about previously, but really is a great tool for making sure that you leave your mark for the future. So I always like to end on a bit of a lighter note by bringing up some strange wills in history, just to show that you really have a lot of power to do, frankly, whatever you want in your will. And these three examples are some of my favorites. So Heinrich Heine, this German poet, he left his estate to his wife on the condition that she remarry. And his justification for doing so is he wanted to ensure that there would be at least one man to regret my death. So a bit of a sense of humor with him. Mark Gruenwald, he was a comic book writer and illustrator. He requested that his ashes be mixed with ink and used in one of his comics. And amazingly, his wish was actually fulfilled. And lastly, a local example, you may have heard of the Great Stork Derby in the 1920s. The Canadian lawyer here, he died in 1926. He left a huge sum to the woman who could have the most children in the decade following his death. And 4 mothers received $100,000 each for having 9 children. And remember, this is $100,000 100 years ago. So some serious money. And quite a lot of hysteria caused by this individual. So thank you very much. I hope you enjoyed.
Well, thank you so much, Matthew. I know we're going to have a few questions, and I'll just let some of those gather in the Q&A. And I actually have a few questions that I wanted to posit to you, but I just got to say on that last one, it was actually the story about the stork babies was featured in the local paper here not too long ago, because the house where he had resided is just up the street from me in Scarborough. So I actually knew the stork story, which was just phenomenal. And I do want to comment on a couple of things that you said. One of the things that struck me, and we did I have learned in each one of these webinars from all of our experts, and it always amazes me the breadth of your knowledge and what you can shine a light on. And this concept that taxes are basically equal to charitable gifts, that concept thinking of it in that way, as you said, it kind of presents itself as a, well, gee, that's not really much of a choice. I'd rather give to charity than give taxes to, just to the great big bowl of resources that gets handed out to, and I have no control over. Whereas if I can do charitable gifts, I can actually have some control. So I thought that was a very good piece of information for me to think about. And then the other was I think I mentioned this to you before about that will that was just very simple. I think it was my great grandfather wrote a will, and it said, "I'm giving everything to my son John." John must have been a popular name, and except for my daughter Mary gets the cow and the feather bed. And it was so indicative of the time, right? It was written out and in handwriting and then signed. And so we have that's sort of part of our family folklore, but both of those brought up ideas for me and just made me think. But maybe I'll just ask one question. You mentioned will kits. And when we deal with a number of legal issues. I mean, as an executive director, I have to deal with, just even signing papers to have our rental agreement for the building. Every single word counts, and sometimes we're negotiating legal issues when we're talking about protection of caribou or maybe mercury in a mining project. Various kinds of things that we will have negotiating, and every single word counts. And so one of my questions to you is, you said will kits are getting better, but I guess it sort of, this discussion today has made me think, is there a fear in maybe an unintended consequence from some of these will kits? And you're supposed to fill in the blanks or answer certain questions, but does it create a possibility for some unintended consequences, I guess? So I'll just ask that question.
Well, that's a good question, Janet. And I think the short answer to that is yes, it does. They're still relatively new. And the reason why I said I think they're getting a little bit better is because, as I understand it, they're adding a little bit of flexibility and trying to tackle some of those, I'm going to call it inherent issues that are going to come up when you have a kit that's meant to be one size fits all. Now, the problem is they are relatively new, so we haven't seen a ton of examples as to what happens when someone passes away and they have a will that's been put together by one of these template programs. And what are the implications of that? I fear it, and I know a lot of my colleagues in the community fear it too. And one of the issues that we're kind of alluding it too is this issue with digital assets, for example, digital assets and other intangible holdings. And again, I'm often asked, what happens with all of these assets if they're not mentioned or not set out in a will? And the answer is, we're not entirely sure yet, because it just hasn't been around for long enough. And most of the people who have mentioned digital assets or used a will kit like this are still with us. And most wills, frankly, will not be challenged and will likely be okay. But people in my shoes and in the community are worried about those small percent of cases where there is an issue. So sorry to go off on a bit of a tangent there, but I think it's an interesting comparison in that sense that I think the future is going to be really interesting to see what happens. And I'm sure people don't want to be, let's call it the test case when it comes to something like this.
Yeah, or leave your family to be the test case.
Yeah.
The other interesting piece I found that you were talking about, this idea of getting your will probated. So probably other people are familiar with this as well, but often when somebody passes, the will goes into probate. So that can be like 6 months, a year. We have very fortunately been in the beneficiary in some cases of people's wills, their last will, and it made a bequest to us. And so we have to wait for the will to get probated, and that can be a year, maybe even 18 months in some cases. And so I think what you were suggesting was that people get probate done before they pass. Like when you sign your will, you go and get it probated. Is that correct? Am I reading that right?
Not exactly.
Okay.
Let me clarify a little bit. So really, you can only apply to probate a will after somebody has passed
Okay.
away. But what you can do is try and minimize the amount of assets that would be governed by that will.
Okay.
So if somebody's already passed away and they have certain assets that wouldn't necessarily be governed by the will, such as a life insurance policy or an RRSP, those assets can be dealt with notwithstanding your probate application is
Okay.
outstanding. So, and as you said, Janet, it can be frustrating. It can be a year, it can be longer, and oftentimes it depends on the jurisdiction. In Toronto, it can be a little slower than some of the surrounding areas. And just like everything these days, things like COVID have thrown a wrench into our normal timeline. So especially these days, it's difficult, it can be time consuming, it can be really frustrating. So it's just one of those things that unfortunately we have to deal with.
Okay. And then I actually have a question for all three of you, which listening to all of you and your expertise, each of you in sort of different ways have brought to the table, what it's made me think that, you know, when you think about, well, I'm going to go get a life insurance policy and I could take that avenue, or maybe a donor directed fund, or perhaps I'm going to go and talk to Matthew about getting a will done up. Is there a one-stop shop for all of this? Because it seems like I almost feel like I have to become a little bit of an expert on this, and I don't know what our listeners are people tuning in are feeling like. But in terms of, you've all offered so many different ideas that seem to me, when collected together, could really make a very robust estate, and thinking that through. And so I just wondered if when people are looking for this, what they should be considering or who they should be talking to.
Well, if I could take this question, I think that there is no a single person for all situations. However, it is good to have a conversation with your financial planner and a lawyer when you are considering these things. And if you have personal corporation among your assets, then accountant should be included as a must into this group of people.
Okay.
When you work with all your assets and putting them together, that's when a financial planner could be instrumental, because they have a broader perspective of what's available in Canadian financial landscape to serve this or that matter. What they may not know is how exactly this particular instrument will be treated at the moment of death. And that's when lawyer comes in and say that, oh, you can do that, but that could be contested by your ex-wife, for example. Mm-hmm. And of course, when it comes to a corporation, I wouldn't put anything in writing without talking to the accountant.
100% agree with Vlad. When working with my clients, I treat them like they're the CEO of their life. And what do they need to surround themselves with, or experts in different areas that they are not experts in. And so to have a properly set up structure for everyone's life, you know, you should have a trusted accountant, a trusted financial planner, a trusted lawyer, even your dentist, your doctor, like everything in your life needs to be well thought out and put together. So 100% there's not one person that can do it all. If they do, I would run to the other side of the room. So definitely be careful. And each of those components, you have to feel very comfortable with the person. So if there's anything that they're not able to help with, answer, or you're feeling a little bit funny about, don't hesitate to get second opinions. And, you know, I think we all feel like that we provide our clients with the best advice possible, even if in the end, it may not be beneficial to whatever situation, we will give our best advice. So definitely find a good team for your life.
Okay, that's actually a really nice analogy, being the CEO of your life and having a team there, especially in areas that you might not have an expertise, that you're just bringing your, you know, kind of maybe even a hockey coach, you're bringing on the star forward who's going to help you actually get where you want to go. So just to follow through on the Maple Leafs jersey. Matthew, did you have anything to add on that question?
I'm not sure I can add much. Those were really good answers. I think that mostly covers it. As Candice said, I'd be wary of someone who said that they could do everything in that list. It would be easy to stretch yourself thin in that regard. So I just echo what Vlad and Candice said.
Okay, thanks very much. So I think Vlad and Candice, you were going to provide some comments now and do a little bit of a wrap up or a review on the previous sections. I'm not sure which of you is going to kick that off, but
Yes, well, thank you, Janet. Thank you to Wildlands League. And we've had a tremendous time, very fun time, putting on this trio of seminars for your donors. And so thank you so much to everyone for participating in this webinar series. It's Estate Planning Simplified Considerations Beyond the Will. Now that we've wrapped up our third session on simplifying the estate transfer process and going over potential legal issues with Matthew, we did want to just go through on the next slide a summary, a very quick summary on what we did talk about in the previous ones. And so just to emphasize again, strategic philanthropy is much more than making a one-time donation to your favorite charity. And it's about incorporating tax strategies to help out and to empower you to support the causes you believe in, like the Wildlands League. And as you heard from so many of the different topics and things that we were talking about, it is all a little bit tax related, and it is a bit about being efficient with what you're doing. The charities will be better able to plan and achieve their long-term goals while meeting their immediate needs when they are involved in your planning and plan giving strategies. So don't hesitate to talk to the charities themselves and the advisors you work with to come up with a plan. And so a quick summary on the first webinar on taxation. This was taxation of different parts of your overall estate and investment portfolios. And we highlighted some highly effective tax minimization strategies. We talked about the deregistration of your RSP and RIF accounts over time. We described the most effective use of life insurance policies. We went over an example of donating appreciated securities and also reviewed how to create a legacy by using a donor advised fund or private foundation.
Well, and in the second webinar, we focused on the estate bypass and equalization. And it really relates a lot to the question about probate that Janet asked. When you are trying to make sure that your charity or your beneficiary gets something without a delay, without any extra fees that might not be necessary in this particular case, you might consider estate bypass. There is nothing that could save your estate from probate if, say, bank holds some assets and they want to impose this, but you could structure yourself, your estate, the way that some assets will bypass it. So we talked about different instruments. We showed to you how to use segregated funds and life insurance to cascade the wealth over a few generations, make gifts and donations in complete privacy, and also how to equalize your estate between few beneficiaries. And today's session was about the legal side of the process, how to make sure your will is legal, how to minimize the risk that your will is going to be contested in the future, and how to fulfill all legal requirements in this new and somewhat unfamiliar world of COVID-19. Drafting your will and preparing the estate transfer is a complex process. Unfortunately, there is no easy button for that, and it could even feel intimidating at times. And it's important to remember that you don't have to go through this alone. There are people that are ready to help you. It's your lawyer, it's your accountant, your financial planner, even your charity. Thank you for spending this time with us today and in the previous sessions.
yeah, so I'm going to conclude today's session by giving my heartfelt thank you and just expression of deep appreciation to Candice and Vlad and Matthew for providing their expertise and volunteering with us to do this webinar series. I personally have learned a great deal from this. I've taken something from each one of those. I've been impressing some of my friends with my knowledge of how you can do cascading wealth with insurance. And I've talked to some people, it just sort of reminded me of the importance of donor-assisted funds, for example, and how those can really help. And so for each of these, and I love Matthew's presentation as well, it made me think, oh, maybe I should write everything out. And then I thought, oh, for sure, I'm going to put Jeffrey instead of Jonathan. That's definitely going to happen. So it just made me think, yep, got to get there to see my lawyer. So thank you so much for bringing all of your expertise to this. It's really helped me personally. It's helped us as an organization. And I hope it is given something to our donors and the people who support us in helping them navigate these waters to getting their estate planned. So thank you so much for your time. Thank you.